Good morning. I hereby call to order this 7th meeting of the Pennsylvania Public Utility Commission for the year 2019 and ask that you please stand for our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and we have a big crowd here today, and we want to welcome our youth that are with us. This is Take Your Daughters and Sons Day to Work, and we are so happy to have them here with us at the Pennsylvania Public Utility Commission. We know that their parents or their relatives are with them, and we're just excited to have them learn all about what we do here at the Commission. So before I go on to our meeting, I just want to remind you to please take note of the safety information on the inside of our agenda. Also to remind you that the Commission will act on various matters at today's meeting, which is open to the public. However, since adequate forums have been made available for public participation in cases before this Commission, there is no opportunity for the public to address the Commission at this public meeting. So with that, our first matter on today's agenda is the approval of the minutes for March 28, 2019. And I call upon Commissioner Coleman, who is the editor.
Thank you, Madam Chairman. I've reviewed the minutes of the March 28, 2019 public meeting, and I move they be approved as submitted.
You have heard the motion for the approval of the minutes. Is there a second?
Second.
Second by Vice Chairman Sweet. Any further discussion on the minutes or further edits? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. And now we will move on to today's agenda, and we'll call up our Secretary Rosemary Chiavetta, to lead us through the agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by Director Monahan and the Bureau of Audits. It is recommended that the Commission, in an omnibus motion, adopt both audit reports on page 1.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Sweet. Is there any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2 and matters presented by Director Sophie and the Office of Special Assistance. It is recommended that the Commission adopt the proposed opinion and order granting PGW's petition pending review of and consideration on the merits.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the proposed opinion and order regarding the petition of the PECO Energy Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Place. Any discussion?
Madam Chair,
Vice Chairman Sweet.
I have a joint motion. Please place our joint motion upon the record as if I had read it in its entirety. Before the Commission is the recommended decision of Administrative Law Judge Angela T. Jones, denying a proposal for a pilot program filed by PECO Energy Company for an advance payment program, and the waivers of the Commission's regulations necessary to implement the plan, and the exceptions and reply exceptions filed by PECO, the Coalition for Affordable Utility Services and Energy Efficiency in Pennsylvania, Tenant Union Representatives Network, the Office of Consumer Advocate, the Commission's Bureau of Investigation and Enforcement, and finally, the Retail Energy Supply Association. The program is proposed as a 2-year pilot, limited to 2,000 customers with smart meters and a household gross income above 150% of the federal poverty guidelines. They are existing customers or new applicants, and all participation is strictly voluntary. Participants must have access to the internet or text-capable cell phone. The plan would be available to both default and shopping customers and to electric-only or dual-service customers. Participation is limited to those without a delinquency and to those who carry a maximum delinquency of $1,500, for which 25% of the funded amount will reduce delinquency, while 75% will be applied to future service. PECO will permit participants to use any existing payment channel to pay or load funds into their account prior to usage of service, and the beginning amount to be prepaid must be at least $40. Each day, the account balance will be reduced to reflect the charges for the prior day's usage. We agree with the ALJ that there are some aspects of the plan as proposed which are not in the public interest, and we appreciate the diligence of the parties and the ALJ in documenting some of the weaknesses of the proposed plan. We agree that there are some aspects which are not acceptable, even in a pilot program. However, at the same time, it is clear that the use of advanced smart meters has opened the door to new possibilities that were not available under the prior metering systems. Since smart meters can transmit daily usage, the traditional billing cycle, where the meter is read monthly, is no longer the only way to approach billing. Customers using the prepaid program can add funds to their accounts in a manner that suits their needs, perhaps adding funds every 2 weeks that coincides with their paychecks, instead of being required to make one large payment monthly. This would more accurately reflect the way money flows in and out of their particular households. It would be unfortunate to miss an opportunity to see how this type of program works for customers who wish to use it. We are mindful this is a pilot program, that participation is strictly voluntary. We are keenly aware of the OCA's warning that prepaid programs can become concentrated among low to moderate income customers. And we want to be clear that this approval today is meant to permit an innovative pilot program consistent with available technologies to allow customers and applicants more convenience and flexibility. While we are hopeful that there will be benefits to this pilot, we cannot evaluate its success until we've gathered data, support, or weigh against its continuation. It is even possible that this prepaid service will provide a means of obtaining or continuing service to payment-troubled customers who may be barred from commission assistance by the provisions of Chapter 14. We remind PECO that this program is not to be used as a substitute for the company-issued payment arrangements that it offers to payment-troubled customers now. PECO is expected to continue to negotiate payment arrangements with payment-troubled customers in good faith. We assure all stakeholders that this approval is not intended to circumvent or reduce the consumer protections to which customers are now entitled. If at any time during the pilot these protections are imperiled, PECO must suspend the program and may do so with a letter to the Commission at this docket. With the warnings of the public advocates in mind, we will give PECO an opportunity to make a compliance filing that includes modifications. We recognize that we have made significant modifications to the proposed program, and that those modifications were discussed and are supported in the underlying record. If these modifications are not acceptable to PECO, then PECO will simply not file its compliance filing, and the program will not be developed. However, a compliance filing that does not include these modifications will be rejected. Therefore, we move, first, that the exceptions of PECO Energy Company are granted in part and denied in part consistent with this motion. Secondly, that the exceptions in the Office of Consumer Advocate, the Commission's Bureau of I&D, and Cause PA Turn are granted in part and denied in part consistent with this motion. Thirdly, that the exceptions of the Retail Energy Supply Association are denied. Fourth, that PECO Energy Company may file a compliance plan within 60 days of the date of the Commission's final order, which creates a prepaid metering program with terms as proposed and modified as follows. A customer who is not paid during the 5-day grace period is automatically removed from the program and returned to standard payment terms and conditions, including, but not limited to, the traditional termination provisions. B, a participant who informs PICO that a medical certification will be provided is automatically removed from the program and returned to standard payment terms and conditions in order to provide full consumer protections to those in need. C, existing deposits may be eligible for application to the program, but may be returned to the customer at the customer's election. Customers holding an active protection from abuse order are eligible for this plan, but must be informed of the other payment plan options in order to determine which may be the best choice for them. And D, PICO may not initiate a fee for payments made on the website or customer portal. Number 5, the waivers of 52 PA Code 56.17 sub 3, 56.173 small I, 56.17 Roman numeral 3B, 56.53, and 56.173 Roman numeral 2 small Roman numeral 2D are granted for purposes of allowing the pilot program only, and that the waivers will expire at the end of the pilot program. 6, if PICO chooses not to file a compliance filing within 60 days of the final commission order, this docket may be closed by secretarial letter. 7, that PICO shall serve a true and correct copy of its compliance plan, if any, upon all the parties to this docket. And finally, number 8, that the Office of Special Assistants prepare an appropriate opinion and order consistent with this motion. Thank you.
Thank you. You have heard the joint motion of Vice Chairman Sweet and myself. Is there a second to the motion?
Second.
Second by Commissioner Place. Any discussion on the joint motion?
Madam Chairman, I want to thank my colleagues and their staff for seeking to find a way forward in this pilot program for PICO, and I'm hopeful that it can be implemented and intend to vote yes.
Thank you very much. Any further discussion on the joint motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Turning to page 3, it is recommended that the Commission adopt the proposed opinion and order in the application of PPL Electric Utilities.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion?
I have
Bevy of statements.
a statement on the motion, if you like.
Commissioner Place.
All right, thank you. Madam Secretary, I ask that my statement be placed in the record as if I had read it in its entirety. Before the Commission today for consideration and disposition of the exceptions of PPL Electric Utilities Corporation filed in October 2018 concerning the recommended decision of Administrative Law Judges Myers and Cheskis in the above captioned proceeding. The Office of Small Business Advocate filed replies to exceptions in the matter on October 11, 2018. The RD denies PPL EU's application for approval of a corporate restructuring, which would inject 2 new Delaware holding companies, PPL Subsidiary Holdings, LLC, and PPL Energy Holdings, LLC, because PPL EU and its current parent, PPL Corporation. I'll rewrite that last clause because I misspoke. The word should be between PPL EU and its current parent, PPL Corporation. Okay. The RD found that PPL EU's proposed transaction constitutes sufficient change in control to trigger a commission review under sections 1102 and 1103A of the Public Utility Code. It also falls squarely within the parameters of the Commission's policy statement governing utility stock transfers, as the proposal results in a new controlling interest of PPL EU and in a different entity becoming the beneficial holder of the largest voting interest in the utility or parent, regardless of the tier. In reviewing this matter, I agree with the ALJ's jurisdictional analysis. I also agree with the ALJ's conclusion that the applicant failed to show that the proposed intercompany restructuring is necessary or proper for the service, accommodation, convenience, or safety of the public as required by Section 1103 of the Public Utility Code. In addition, the ALJ's reasoning that in order to satisfy the standard section of 1103A as prescribed by the City of York case, The proposed transaction must, quote, affirmatively promote the service, accommodation, convenience, or safety of the public in some substantial way, end quote. Further, the Supreme Court explained in the Popowski case that demonstration of the affirmative public benefit does not require that every customer receive a benefit from the proposed transaction. The paramount legal requirements for approval of a proposed transaction in this proceeding are well established regarding this Commission's jurisdiction, review standard, the company's burden of proof to demonstrate affirmative benefits. Although PPLEU argued that the proposed transaction strengthens the financial position of PPL Corporation, provides an ultimate source of equity capital for PPLEU that may benefit PPLU's customers through PPL Corporation raising capital at reasonable rates, the company does not provide sufficient record evidence that these benefits meet the standards set forth in the City of York and Popowski cases. Rather, the OSBA pointed out that PPLU has admitted through this proceeding that no cash distributions related to PPLEU are contemplated as a result of the proposed restructuring. Thus, there is no cash benefit to PPLEU. OSBA also pointed out that the corporate restructure will reduce tax payments to the Commonwealth of Pennsylvania without any commensurate reduction in taxes paid by PPLEU's ratepayers, which does not constitute a public benefit. Further, OSBA pointed out that the alleged tax savings may be dissipated through dividend payments, alternative investments, or enriched PPL Corporation's shareholders. I agree with OSBA that the record evidence does not support that the company has proven affirmative public benefits as required by the statute and case law. As stated previously, PPLEU has the burden of proof to demonstrate that it has met the legal requirements to prove the proposed transaction through record evidence of affirmative public benefits, not just corporate benefits. PPLEU has not met its burden of proof, and the Commission is not required to furnish the necessary legal requirements for the company in this proceeding. At the same time, PPLEU's options are not limited here. The company can re-examine the proposed transaction and determine whether it will refile a corporate restructuring that achieves demonstrative affirmative public benefits. In addition, evidence can be introduced regarding the impact of Act 40 on corporate restructuring. I stand ready to review any future filings by the company. Thank you.
Thank you, Commissioner Place. Any further discussion?
I'll go next, Madam Chairman.
Commissioner Kennard.
I actually have two statements.
Okay.
One's easy. It's a statement that Rachel Maurer of my staff was a financial analyst with I&E at the time and therefore has not consulted with me or provided me with advice in this matter. I'm afraid we're putting ourselves into a box here. PPL is proposing a restructuring that would simply insert two new affiliated entities between itself and its parent company. There's no ultimate change in control. The utility still continues to be owned by PPL Corp., and the managers do not change at PPL Utilities. Would have no effect on management. There'd be no change in officers. The PPL Utilities would still continue to be 100% owned by PPL Corp. The operative section in the code states that approval is required where utility ownership or property is transferred. I can see that a literal interpretation of that, it covers a situation where PPL utility stock is being acquired by another entity. But in this case, that entity is still owned by the same parent, subject to the same rules in the same building with the same officers. This commission declared in 1994 that the statute was in the nature of a change of control statute and not a transfer of property statute. And that's the interpretation the commission has applied to this area of law for the last 25 years. So I am not aware of any internal reorganization that's ever been disapproved by the commission. And what we've done is revised the code to allow for a transfer of the corporate level ownership to another entity. So when we had GPU being sold to First Energy, we were able to reach up to that because of our interpretation of the code. And I don't think we should have two internally inconsistent points of view. So I'm afraid we're placing ourselves into unnecessary legal box. I do believe that they have pled affirmative benefits. So in the alternative, I would apply the standard and find alternatively that there are benefits. PPL contends that managing tax liabilities benefits its customers and makes it financially stronger, more efficient to operate, makes them more capable of raising capital. The MCI case demonstrates that the benefits need not be quantified and can be of a generalized nature. And again, we have approved multiple reorganizations in the last 25 years, and none of them have been turned down. So I think as part of our deliberation here, we need to consider the practical ramifications of what we're doing. It's unfortunate that Act 40, which got rid of consolidated tax savings, so the tax savings at the parent level are not flowed down to the operating company level, is being used now to say, well, there is no tax benefit flowed through to customers, therefore we can't approve this transaction. I really don't think that the legislature intended it, and I really don't think anybody really thought that this was going to be the outcome. It was merely an attempt to deal with consolidated tax savings as a rate case issue. So accordingly, I'm going to vote to grant PPL's exceptions and would reverse the recommended decision. I do want to acknowledge the openness of my colleagues. They seem to have equal concerns in varying degrees over the practical outcome of this, and look forward to attempting to resolve it. Hopefully it's not by statute, but we need to find a way to allow internal reorganizations. Thank you.
Thank you, Commissioner Kennard. Any further discussion?
Chairman, I also have a statement on this matter as well. And I would just say for the young visitors today, this is a great civic lesson for you where you can hear the various points of view from each commissioner. And I guess it would suggest that reasonable minds can disagree from time to time. So hopefully this is a good lesson this morning. As Commissioner Kennard has indicated, what we're talking about here is two new holding companies that will be established between the parent company, PPL Corp., and PPL, the regulated utility, and that's where we come into play here. The reason this is before us this morning is that the Commission has an obligation to grant a certificate of public convenience, and in doing so, we look at this to see is it necessary or proper for the service, accommodation, convenience, or safety to the public under Section 1103 of the Public Utility Code. In evaluating the transaction under Section 1103, excuse me, the Pennsylvania Supreme Court held that the Commission must find that the transaction provides affirmative public benefits. Excuse me. And that's really what we're talking about this morning, is whether the company has put forth enough evidence for us to believe that that is in fact the case. The Pennsylvania Supreme Court further explained that the affirmative public benefit need not be quantifiable, meaning that there may be other aspects of this transaction that can be viewed as being in the public interest. So the Supreme Court says that it may not necessarily need to be quantified, where it may be impractical, burdensome, or impossible to do so. Now, the recommended decision, as you've heard this morning, recommends that the application be denied because PPL has failed to satisfy this particular section of the Public Utility Code. Based on the evidentiary record in this case, in accordance with the Commission's precedents, I agree with Commissioner Kennard. I believe that PPL has met its burden of proving that the proposed intercompany restructuring will provide an affirmative benefit. And here's why. I believe that the proposed restructuring will allow PPL Corp., now this is the parent company, to be more efficient in managing its operations and its finances, specifically its cash flow. A financially stronger and more efficiently operated parent company will have a reduced capital need. Okay, so if you can follow the conversation of the parent company being able to operate more efficiently and how that flows through to the regulated utility and the reason we're here this morning. In operating in a more efficient way, it allows the company to reduce capital needs and to improve the ability to raise capital at more favorable rates, thereby benefiting the PPL, the utility customers here in Pennsylvania. PPL Corp is the ultimate source of equity capital for the regulated utility PPL. PPL correctly noted that while PPL raises its own debt directly in public markets, it is PPL, the parent corporation, that raises the equity capital for PPL. Since PPL Corp contributes to the capital of PPL, the regulated utility, there is a benefit to PPL and its customers if PPL Corp has greater access to less capital that it can then pass down through to the regulated entity. More efficient access to capital has been previously recognized by this commission as an example of an affirmative benefit. I believe that PPL's proposed intercompany restructuring presents sufficient affirmative public benefits, even if those benefits may be indirect and admittedly modest. They are there. This is to be expected for an internal company reorganization that does not affect the rates and conditions of service. And it's for those reasons this morning that I would have approved the application, so I will be voting no on this morning.
Thank you, Commissioner Coleman, and also thank you for taking the time in your statements to explain the intricacies of this case to our students that are here today. I really do appreciate that. Any further comments?
I also have a statement.
Vice Chairman Sweet.
And excuse me, would echo Commissioner Coleman's remarks, and so I won't rant and rave and say he was out of order and anything terrible, because he wasn't. He made a good argument and a good case. Unfortunately, I will not be able to agree with him. When I first saw the caption of this application of PP&L for approval of a restructuring, I thought it was going to be a simple case. Based on my past legal work and understanding of corporate restructurings, I first assumed that the restructuring application could go forward without a new certificate for public convenience. But sadly, such a routine approval is not compelled by the evidence submitted, excuse me, or clearly permitted by the applicable provision of the Public Utility Code at Section 1102A3, or the Commission's construction and administration of this provision as set forth in our policy statement at 52 PA Code 69.901, and the cases evolving therefrom. Even PP&L appeared to concede this point in their initial application on page 4. I'm very sorry. To me, there's a two-pronged inquiry. First, does the approval of the application require a new certificate of public convenience? And secondly, if so, does this application justify such an approval? The answer to the first question is yes, based on the statute, based on the concession I mentioned further, and based on the way the Commission has handled these matters in the past, that the statute, the policy statement, this history, and the applicant's failure to make a compelling argument to the contrary. I have difficulty believing that the General Assembly intended this interpretation of 1102, but for the past 20 years, that's been the case, although perhaps not precisely to the set of facts like those asserted in this case. Since a certificate is required, the second question, and the question addressed by my colleagues, is whether PP&L met the so-called affirmative benefits test as set forth by the Supreme Court in the City of York decision, which was cited. My answer is they've not met the standard. I searched the record in vain to find any concrete examples of benefits to the customers of PP&L or other affected parties other than the PP&L corporate family. Despite being asked several times for such examples, the only specific item put forward by the company was the ability to avoid, through the creation of 2 Delaware corporate subsidiaries, certain Pennsylvania taxes. And that's hardly my idea, nor do I think it was the Supreme Court's idea, of an affirmative public benefit for Pennsylvania's residents and taxpayers. Other than this specific example, we're left with a record that contains only generalizations on the subject. Vague and speculative assertions about improved cash management, greater flexibility in merger and acquisition situations, and more favorable treatments in the capital markets are just not sufficient to meet the City of York standard. I must regretfully vote to disapprove the application. I wish the statute was clearer, the policy statement more on point, the Commission's application of these legal guidelines more nuanced, and the evidence on affirmative public benefits more robust and more compelling. But none of that is the case. My colleagues to the left made good arguments, but they're not clearly and specifically outlined in the record. And they're certainly not guaranteed to pass from parent to regulated utility in the order that Commissioner Coleman described. That is the ordinary corporate flow, but there's no real meat to those bones in the application and the evidence submitted therefrom. This outcome's troubling to me, but PP&L, as Commissioner Place mentioned, is not left without options. Be it through a new application, an appeal of our decision would allow for an appellate court consideration of the thorny issues raised here, or clarification by the General Assembly. Thank you, Madam Chair.
Thank you very much.
Madam Chairman, point of order. My staff always writes in red at the top of my statement, since I do a speaking version, that I should move it as if I had read it in its entirety in the record. So I'd like to do that for the record.
Thank you very much. Any further comments? Hearing none. All those in favor of the staff recommendation say aye.
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 Any opposed?
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 The motion passes 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman.
Finally, on page 3, it is recommended that the Commission adopt the proposed opinion and order in the complaint of the Bureau of Investigation and Enforcement versus NECC Telecom.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended in an omnibus motion that the Commission adopt all the items on page 4, beginning with the tentative cancellation of electric generation suppliers and continuing to include both items on page 5, ending with the application of Resource Energy Solutions.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Vice Chairman Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 6, and matters presented by Chief Counsel Panque and the Law Bureau, it is recommended in an omnibus motion that the Commission adopt all of the items on page 6, beginning with the implementation order of Act 58 and continuing to include the single item at the top of page 7, the petition of the Superior Water Company.
Is there a motion to adopt the staff recommendations?
So moved. Second. Third.
Motion by Commissioner Kennard, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 8, and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt ALJ Haas's recommended decision regarding the Delaware Sewer Company.
Is there a motion to adopt the staff recommendation?
So moved?
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Under discussion, I do have a motion, so I will turn it over to Vice Chairman Sweet to preside.
Thank you, Madam Chair, and you are recognized for the purposes of offering your motion.
Thank you very much. I ask that my motion be spread upon the record in its entirety. Before the Commission is a 529 investigation pertaining to Delaware Sewer Company. The parties to the proceedings filed a settlement, and the presiding judge recommends approval. I support approval of this Section 529 acquisition, which permits Pennsylvania American Water to acquire the assets of Delaware Sewer Company. However, I am concerned that the ALJ's decision may manifest the incorporation of ineligible property pursuant to Section 1351 of the Code into Pennsylvania American's long-term infrastructure improvement plan. Here, the recommended decision incorporates the entirety of Pennsylvania American's plan for improvements for its existing LTIP. In order to ensure Pennsylvania American's LTIP does not include any ineligible property, I propose that the plan for improvements submitted by Pennsylvania American is approved, consistent with Section 529, and the eligible property and expenditures from the plan for improvement should be incorporated into Pennsylvania American's LTIP. Further, to the extent the settlement and its accompanying plan for improvement contain non-disc eligible property, Pennsylvania American may establish a regulatory asset in order to claim appropriate rate making and revenue recovery within its next base rate proceeding. Therefore, I move that, 1, the settlement agreement in the investigation instituted per Section 529 into whether the Commission shall order a capable public utility to acquire Delaware Sewer Company is approved as modified by this motion. 2, the plan for improvements submitted by Pennsylvania American Water Wastewater Operations is approved consistent with 66 PACS Section 529J. 3, the eligible property and expenditures constitute to the plan for the improvement shall also be approved pursuant to 52 PA Code Section 121.5A and incorporated into Pennsylvania American Water Wastewater Operations existing LTIP, and the Pennsylvania American Water Wastewater Operation may establish a regulatory asset for any ineligible property in order to claim appropriate rate making and revenue recovery within a future base rate proceeding. 4, the Office of Special Assistance draft a tentative opinion and order consistent with this motion. 5, the Delaware Sewer Company, Pennsylvania American Water Wastewater Operations, or any other active parties and interested parties shall have 10 days from the issuance of the tentative opinion and order to file comments. 6, should Delaware Sewer Company, Pennsylvania American Water Wastewater Operations, or any other active and interested parties not file any timely adverse comments, the tentative opinion and order shall become final. And 7, that a copy of the entered tentative order shall be served upon all parties of the record in the instant proceeding.
Thank you, Madam Chair. Is there a second?
Second.
Seconded by Commissioner Kennard. Any further comment?
I have a comment, Mr. Vice Chairman.
Recognized.
Thank you. The Delaware Sewer Company wastewater system is in exceedingly poor condition. Among other problems, the existing elevated sand mound is not fenced, has little vegetation cover, is prone to soil erosion, and has deep ruts in it caused by off-road vehicles. It has exposed piping, so the discharge from the pump station ponds on the surface. Under the settlement before us today, PA American has agreed to purchase substantially all of the assets of this system and remediate them. I want to commend the parties on their successful resolution of this case. I want to thank PA American for agreeing to undertake this problem child of ours. And thank you, Madam Chairman, for your practical resolution of the cost recovery issue.
Thank you. Any additional comment? Hearing none, we'll have the vote. All in favor?
Aye.
Aye. Opposed? The motion is carried 5-0. As amended, is there any objection to the same roll call? Seeing none, the motion as amended is adopted, 5-0. Thank you.
Thank you very much.
You're welcome. See, Coleman has set this tone that we have appropriate demeanors. I'm trying to comply.
It is recommended that the Commission adopt ALJ Haas's recommended decision in the application of CSX Transportation.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, that concludes regular agenda. Turning to the carry-in agenda. On page 1 of the carry-in, it is recommended by the Office of Special Assistance that the Commission adopt the appointment of Ms. A. K. Tyberg to the TRS Advisory Board for a 2-year term that will expire on January 31, 2021.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order in the matter of Senator Andrew Dinniman versus Sunoco Pipeline LP.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion?
Yes, I have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before us today for consideration is the March 29, 2019 letter and affidavit filed by Sunoco Pipeline LP verifying the Pennsylvania Department of Environmental Protection issued approval to restart construction of the Mariner East 2 pipeline at the Shone Road work location in West Whiteland Township. This particular location is subject to certain requirements in the Commission's June 15, 2018 and August 14, 2018 orders, including that work is enjoined at 4 locations, one being Shone Road, because Sunoco had not received permitting authority from DEP to continue construction activities. At the same order, the Commission directed Sunoco to file supplemental verifications or affidavits issued by DEP for the appropriate permissions for continued construction of the ME2 and ME2X pipelines in West Whiteland Township, and that the Commission would render a disposition in the submitted filings. Sunoco has filed supplemental information as directed by the prescribed ordering paragraphs. Specifically, in Sunoco's March 29, 2019 letter, the company requests that the Commission lift the injunction on construction of the ME2 pipeline at the Shone Road work location by secretarial letter in accordance with the above-mentioned August 14, 2018 order. In response to the company's letter and affidavit, Senator Dinniman, through counsel, advises the Commission that it lacks jurisdiction to grant this request in light of Sunoco's pending appeal to the Commonwealth Court regarding this matter. Sunoco also submitted a reply to Senator Dinniman's response on April 4, 2019. It is important to note that Sunoco filed a motion for certification of the Commission's June 15, 2018 order for interlocutory appeal on 3 issues which the Commission granted in part in July 2018. At that time, I dissented from the Commission's action to grant Sunoco's interlocutory appeal. Shortly thereafter, on September 27, 2018, the Commonwealth Court issued an order indicating that it will consider the issue of standing only and directed that, quote, all proceedings in this matter before the PUC are stayed pending resolution of this appeal, end quote. As stated above, Sunoco is the party that filed the petition for interlocutory appeal, which was granted by the Commission. In taking this action, Sunoco removed the case from this forum and must now accept the Court's broad directive of staying all proceedings in the matter. The Commonwealth Court's order is binding upon the parties in this proceeding and by which the Commission, Sunoco, and Senator Dinniman must abide. Thus, I believe that the Commission cannot grant Sunoco's requested relief and that the company must make the decision whether to petition the Commonwealth Court to return the matter to the Commission for further disposition. Thank you.
Thank you, Commissioner Place. Any further comments or discussion?
Madam Chairman, I agree largely what was said by Commissioner Place. We do have a Commonwealth Court order telling us to stand down and that we are stayed from proceeding further in this matter. What's unclear is whether it's that language was undertaken, and there's no citation in that statement, pursuant to 1701, which would allow rules of appellate procedure, which would allow us to proceed in the implementation of the order even while it's on appeal, or whether it was a more generalized supersedious. There was no supersedious case before the Commonwealth Court, so it's doubtful that that's what he was doing. But nevertheless, the language does appear clear and is rather definitive, so it's up to the parties if they want to approach the Commonwealth Court to find out, to probe the meaning and import and breadth of that statement. So I will be voting yes with the ALJ.
Thank you, Commissioner Kennard. Any further comments? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 2 of the carry-in, in an omnibus motion, it is recommended by the Bureau of Technical Utility Services that the commission adopt both items appearing on page 2.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3 of the carry-in, it is recommended by the Law Bureau that the commission accept the recommendation of the issuing officer in the RFP for geophysical services.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman, that concludes the carry-in. Turning to the supplemental agenda. On the supplemental, it is recommended that the commission ratify the ex parte emergency order regarding Affinity PA LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion?
I have a statement, Madam Chair,
Vice Chairman Sweet.
and I apologize for dragging out the meeting, but this is a rather important matter, and I wanted to reflect some of my own thoughts, at least on the letter as drafted, or the order as drafted. This case involves a petition for emergency relief filed by Affinity PA 3 days ago, April 22nd, 2019, against Zayo Group. Affinity is a certificated competitive access provider, CAP, in Pennsylvania. Zayo is also a certificated CAP and competitive local exchange carrier, or CLEC. Both carriers are competitive carriers, meaning that they provide service in competition with the regulated local exchange carriers in the areas where they serve. Both competitive carriers are parties to a 2013 contract, under which Affinity purchased the right to use Zayo's dark fiber infrastructure to provide broadband service to select customers, including medical and healthcare facilities, educational facilities, governmental entities, in exchange for which Zayo had the right to receive payment. As Affinity averred, quote, the primary purpose, close quote, of the contract was to, quote, provide competitively priced broadband services to rural and underserved customers in Pennsylvania, period, close quote. As Affinity also acknowledged, the contract also included an escalation clause, pursuant to which the fee due from Affinity, quote, shall, close quote, escalate by, quote, 10% every 5 years, or as defined in each applicable schedule, close quote. Affinity averred that it is now operating under a contract under which its fees are no longer financially sustainable, and it is facing several years of financial losses. Affinity claims that under its contract, our jurisdiction is acknowledged by a clause which provides that, quote, to the extent this agreement is determined to be subject to the jurisdiction of a regulatory agency, it shall at all times be subject to such changes, modifications, orders, or rulings by that regulatory agency, including any advanced approval, close quote. As Affinity avers, on April 9 of 2019, Zayo provided Affinity a notice of breach and potential disconnection on the basis of alleged overdue fees of almost $309,000 $309,000, $869. Zayo claimed it would disconnect service if payment were not made by today, April 25th. This, Affinity averred, presented risk to public safety and to property. In a pending Affinity application proceeding to discontinue service, we issued a secretarial letter on April 19th, 2019, precluding Affinity from discontinuing service until the application to abandon service was approved. Faced with the alleged imminent deadline from Zayo, 3 days ago, Affinity filed this petition. Yesterday, facing potentially imminent action that could disrupt service to customers that included medical facilities, we issued an ex parte emergency order, which we are presenting for ratification today. Pursuant to that order, Zayo is prohibited from terminating service prior to June 30th of 2019. Affinity is ordered to pay Zayo $25,000 towards the claimed outstanding almost $310,000 due, and an expedited process to more fully vet Affinity's claims is put into place in the event Zayo challenges this order. I have concerns over the order we're ratifying today. I acknowledge upfront that allegations of the potential imminent termination of a critical service, broadband, provided to a critical set of customers, healthcare providers, raises an alarm sufficient to cause us to seriously consider acting expeditiously to avoid disruption of that service. And this is what we accomplished through the entry of the emergency order yesterday. However, the service we're maintaining in place is a competitive service provided by two competitive carriers pursuant to an agreement voluntarily undertaken by those two carriers. There's no allegation that the contract was entered into by any means other than arm's length negotiations between two presumably competent, similarly situated business entities whose individual needs, at least at the time of execution, fit each other's. And the service whose interruption we cautiously protected against is, by Affinity's own admission, competitively priced broadband services. In further consideration, this raises in my mind a potential jurisdictional issue. I suspect that had we sought to enforce other provisions affecting the speeds or prices at which any competitive carrier provided this service, the first challenge we would face would be to our jurisdiction to do so. Similarly, I also have serious concerns about the invocation of our jurisdiction in what I do not necessarily view to be a traditional intercarrier compensation dispute. Under an intercarrier interconnection agreement and compensation agreement entered into and approved by us pursuant to the Federal Telecommunications Act of 1996. There is no averment that we approved this contract, and thus by its own terms and agreement of the parties brought it under our jurisdiction. And I do not necessarily read the provisions relied upon by Affinity to invoke our jurisdiction, paragraph 7 of the underlying contract, as does Affinity. I also have concerns about our apparent determination that Zayo acted improperly by issuing a notice under its contract that, given the rather substantial amount owed, Affinity was in default of the contract's terms. There's no allegation that Zayo acted improperly under its contract or improperly exercised self-help. There is an argument that Zayo merely sought to protect its financial interest at stake by enforcing the terms of this contract. Finally, while brought into this contractual dispute by virtue of our emergency order issued or entered yesterday, I'm dissatisfied with the level of financial security our order provides the other party to this contract, Zayo. While Affinity offered a one-time payment of $25,000 and we directed its payment within 5 days, Affinity, as the petitioner with the burden of proof, could and should have provided concrete financial evidence to allow us to better conclude whether the $25,000 is sufficient or whether a different level of financial security for Zayo is financially possible. I would have preferred seeing security on both sides of this agreement, security to Affinity and that its customers would not suffer termination of service, but also security to Zayo, that its financial payments owed under the contract are not negated. The amount we approve constitutes less than 1/12 of the alleged outstanding liability that will only continue to grow as Affinity has discontinued any regular payments. Given the imminence of disruption of potentially life-threatening broadband service to healthcare sustaining facilities, I am voting today to ratify the emergency order. However, I concur in the result only and do not support the analysis supporting our relief, as evidenced by my comments set forth in this statement. Thank you, Madam Chair.
Thank you, Vice Chairman Sweet. Any further comments?
Madam Chairman, I share the Vice Chairman's well-stated commercial concerns about this transaction. Zayo is a certificated carrier that is owed $310,000 under the terms of a contract executed between it and Affinity. Affinity as a cap does not dispute that these amounts are due and owing, but says simply that it cannot pay, and that asks that it not be terminated as a result, but that Zayo continue to provide service on a free basis until Affinity can make arrangements to have its customers transferred. Affinity has the burden of proof in this proceeding, and they have not, in their application, described the service that they provide with any detail. If it's true that they provide broadband services, that's none of our business. That's not jurisdictionally commissioned. The FCC preempted this area years ago. So this matter should not even be before the commission, as pointed out by the Vice Chairman. The contract says that to the extent the agreement is determined to be jurisdictional, then we can take jurisdiction. Well, that allegation isn't even made by Affinity to get over that contractual hump. They haven't described with any specificity how they intend to exit the market, other than they intend to do so by the end of June 30th. But again, provided no specificity on how they're going to get there or what's involved. They provided no notice to us, to their customers, if they're going to terminate service. They provided no financials, as the Vice Chairman points out, demonstrating that they can't pay. They've just simply said they can't, and they refuse to. And this arrearage is built up over time. In fact, they've only waited until they got the termination notice to attempt to exit this market. They did nothing during the time that the arrearage was building up. They did not act financially responsibly, in my opinion. In fact, the lack of detail in their petition is truly remarkable. And I'm concerned, to use practical language, that Affinity is slow-rolling Zayo, and in the meantime, doing the same to us, wrapping themselves in the interest of their end user customers for their own interest and financial gain. Affinity has not shown that it can't pay and not explained why it should stay in business. It has not explained the ramifications of its business, or whether it's difficult for its customers, or what the ease is of them getting alternative broadband service. But I tend to believe that they could get it fairly quickly if the customers could get broadband internet service fairly quickly. So I intend to vote no, although I appreciate the Vice Chairman's concurrence in the result, but I'm going to vote no.
Thank you, Commissioner Kennard. Any further comments?
I have one further comment on the matter.
Commissioner Place.
Thank you. The execution question before us today is whether a jurisdictional emergency exists. I support the chairman in her signing of the emergency order regarding the petition for emergency relief by Affinity PA, because clearly an emergency exists. Without this order, there's a real impact to 77 customers, including hospitals, medical facilities, secondary schools, colleges and universities, intermediate units, and district offices of various state representatives, as well as small businesses. These customers will be disconnected, impacting Pennsylvania's citizens' ability to attend school fully, obtain health care, and resolve problems with their governmental representatives. In my mind, this clearly constitutes an emergency that falls within the Commission's requirements to declare one. As noted, Affinity is out of the business at the end of June. This holds us over to that period. It's not indefinite. It's time constrained. They clearly, to be colloquial, have one foot in the grave. This is undoubtedly an emergency that does have impacts, and we need to address it. Thank you.
Thank you, Commissioner Place. Any further comments?
Chairman, at the risk of delaying the closure of public meeting, I do have a comment on this, and I'd like to continue with my civics lesson this morning with our young audience today. And I'll attempt to be as brief as I can here because I know that we've gone long, but I hope that what you're hearing today will inspire you to consider a career at the Public Utility Commission.
Wow.
So, and I don't mean to make light of this particular piece of business. As you've heard, this is a significant piece of business that's come to this commission in relatively short time, in fact, just 3 days ago. And the commission is being asked to referee a dispute between two telecommunication entities. You've heard a lot about the financial transactions between the two, and I want to focus on maybe a little different piece of this, and that is really back to the core mission of this organization, and that's public safety. And I think you've heard a little bit of that in some of the comments from my colleagues this morning. And I think that's really the piece that's compelling me this morning to agree and affirm the ratification vote on this emergency order. Again, you have a dispute between two companies, and what we have heard to this point in time is one side of the story from one of the companies in question here, Affinity. And Affinity is the one that you've heard has the customers, and those customers include hospitals and schools and doctor offices and residents. And what's at stake here is the second company, Zayo, is suggesting a termination, which would terminate the service that's being provided to those entities. And that's really the public safety piece of the mission that concerns me here this morning, that there is a need for the commission to affirm an emergency order to make sure that those services are not interrupted. And I think you can probably see the reason why we would not want to see those services interrupted. From what has been provided to date, again, it is a one-sided story, and I think that there's a second side from Zayo that we really need to hear. But in the interim, I think the appropriate action of the commission is to say, let's not see any services terminated at this particular point in time until we can get to the underlying issues here and help referee this and bring it to a solid conclusion. So I will be voting to affirm the emergency order today, but maybe through a little different path, and that's through the public safety aspects. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further comments? The motion on the ratification of the emergency order. All those in favor say aye.
Aye.
Any opposed?
Nay. Opposed?
The passage on the motion is 4-1, noting that Vice Chairman Sweet is voting in resolve only, and that Commissioner Kennard is voting no.
Madam Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you very much, and we also want to thank our students for being here to witness our public meeting today. We always, during Bring Your Daughter and Sons to Work Day, allow an opportunity for one of our youth to come and gavel out. And today, we are inviting up Olivia Herring, who is the daughter of Allison Herring from our Bureau of Consumer Services, and Jeremy Herring from our Technical Utility Services Bureau. So, Olivia, the gavel is yours.
Gee, you never let me have the gavel.
And without objection, we are adjourned. Thank you.